A group of men were engaging in some very extreme sexual practices. And by extreme, I mean extreme. They even filmed these encounters. They all consented, nobody complained, nobody suffered lasting injury, nobody even reported a crime. Yet, criminal charges were brought anyway after the police got hold of one of the tapes. This case raised a fascinating question. Can you consent to anything in the bedroom, or is there a line? Now, the basic facts of the case are that over the span of a decade, a group of men had been meeting regularly to carry out sadomasochistic activities. We will get to the gory details as the video progresses, but for now, think along the lines of genital torture, branding, and blood play. Unbeknown to the men, one of their tapes was obtained by the police. There were rumours that they were concerned someone might have been killed during the creation of the tapes, but either way, they identified the individuals involved and charged them with assault occasioning actual bodily harm and wounding. Put simply, in English law, a conviction usually requires three things: an act, an intention, and the absence of a valid defence. In this case, there was no dispute about the first two. The men had done what they were accused of, their footage made that hard to dispute, and they had done so deliberately. However, the entire case came down to the final element. Was consent a valid defence? Initially, the trial judge held that consent was no defence, and the men were sentenced. They appealed, but that appeal was dismissed. So, they went to the highest court in the land for a final appeal. At this point, it's worth explaining the gravity of what the courts were considering. The activities went far beyond what most people would consider ordinary sexual behaviour. The courts heard of fish hooks being passed through the penis, hot wax being inserted into the urethra, and the foreskin or scrotum being nailed to a board. In another instance, the scrotum was deliberately incised. Most people would probably read that list and immediately conclude the convictions were justified. But not all the judges agreed. The judges who wanted to allow the appeal argued that the courts were focusing on the wrong thing. The issue was not whether the acts were extreme. Everyone accepted they were. The real question was whether the criminal law should interfere when every participant had freely agreed to what was taking place. Nobody had been forced. Nobody had complained. Nobody had even suffered a lasting injury. These were consenting adults engaging in private activities behind closed doors. They even had code words which would stop the activity if it got too much. In their view, if society wanted to criminalise this type of conduct, that was a decision for elected officials, not the courts. However, the majority saw things differently. They accepted that everyone had consented, but believed there had to be limits. The law already allows people to consent to certain injuries through surgery, boxing, and other recognised activities. But in their view, this was something else entirely. They also pointed to aspects of the evidence that made them uncomfortable. The dominant participants were middle-aged men, while the submissive participants were youths. The courts also heard evidence that alcohol and drugs had been used to obtain consent and increase enthusiasm. One example particularly troubled the judges. One of the appellants had befriended a boy when he was just 15 years old and later introduced him to the lifestyle. While the activities in this case involved consenting adults, the judges were concerned about where this culture could lead and whether younger people were being drawn into it. They were concerned about the wider impact on society. In their view, the law should not be seen to approve or legitimise serious violence simply because the participants agreed to it. They feared that allowing consent as a defence in cases like this would make it increasingly difficult to draw a clear line between lawful and unlawful violence. So, the House of Lords, by a majority of 3 judges to 2, dismissed the appeal and the convictions were upheld. This decision still applies today. In the Domestic Abuse Act of 2021, Section 71 is dedicated to exactly this. Consent to serious harm for sexual gratification is not a defence. This is including the more serious offences of grievous bodily harm and wounding, and even the lesser offence of actual bodily harm. What I find more interesting is that we're always taught how important consent is, but rarely told that the law doesn't even recognise it beyond a certain threshold. More than 30 years later, Brown still forces us to ask the same question. Should consenting adults be free to do whatever they want behind closed doors? Or does the law need to draw a line somewhere, and have they got it right?